Good morning or good afternoon based on whatever part of the country you're in. My name is Candy Chambers with Direct Employers Association, and I'd like to welcome all of you to our webinar today. I think this is kind of fun. We're going to give you an opportunity for an hour at least to ask any question you want about an CCP issue that might be on your mind. First of all, I want to get started on some housekeeping rules, and if you have WebEx issues, you need to email Casey, and that's KACIE @directemployers.org. And if you're having trouble with the audio broadcast, you call in by phone. You just have to click the request phone button on the event panel. And due to the large attendance today, all participants will be muted. One thing I'd like you to do right now is start in any questions that you have, and we will, like I said, spend up to an hour, and then we'll also have our webinar, and we'll take questions on protected vet issues after that webinar. But start writing them in right now in the Q&A and chat sections of WebEx, and just make sure you send your questions to all panelists. And questions will be read out as we go. And this has been approved for both HRCI and SHRM credits. And if you're interested in obtaining credit, please email Kate again at directemployers.org. And I will tell you, I'm in the process of that myself right now, and so you'll definitely want to make sure you get those certificates. Webinar and slides, poor Casey gets a million of these questions all the time, so the webinar and slides will be recorded and available on the pipeline, which is a social community for webinar for members only. And access it at voice.directemployers.org. Last but not least, if you have or you want more compliance updates, you need to text to 55678 the word compliance, and you'll get up-to-date information about our weekend review, any compliance tips or alerts or anything like that. Last but not least, if you want to during the event, use hashtag DEChat. Okay. So right now we're going to talk, like I said, first of all about questions and answers, and I will be taking the questions and either tossing them to John Fox or myself. I think all of you know John. One thing we don't put a lot of advertisement in our webinars, but John, you want to throw out your disclaimer for a second? This is John Fox, one of the best employment law attorneys in the country, so if you wanted to throw out your disclaimer about not providing legal advice.
Oh, it's not legal advice. It's just what we're saying, just the usual lawyer cover your butt business. So I think we're good with that.
Okay, we just want to make sure we have that on record. So since we didn't actually put that, it will be in your slides when we send this out to you. But in the meantime, though, we will also be covering information about the odd odyssey of OFCCP with some issue related to the veteran infographic, and 2 FAQs have come out, and there's a whole real interesting information about that. So we're going to talk to you about what that really means for a federal contractor and your self-ID forms and all sorts of things like that. So without further ado, I'm going to go ahead and get started. John, if that's okay with you.
Good. Let's go.
Okay. So.
And I'm joining Candy here in Indianapolis at DE's headquarters, so we're both in the same room with Casey. So this is good that we're all here as a team.
Yeah, so if you need something, we're easy to reach today. Okay, so this is kind of interesting. I could answer this, but John, I'm going to toss it to you. The Equal Pay Report prognosis.
Yes, in there was rumored to perhaps mirror the equal pay amendments that have recently happened in California. And as a primarily California lawyer, that's where my residence is, although I practice nationwide and have certifications in many states. The California issue is of some small interest, not great interest, I would suggest to you. 2 things. OCP published in its semi-annual regulatory agenda about a month ago that was coming out in December with the sex discrimination guidelines in final form. That is consistent with what they previously published in their semi-annual regulatory agenda 6 months prior, back in what I recall was May of this year. So a fairly confident prediction that they're in the final stages. They can predict precisely at OFCCP when it will go into the Federal Register, because the Office of Management and Budget over at the White House owns that, and will tell OSCCP when OMB has finished reviewing it. But it'll be December, and if not, certainly January. The proposal, as you may recall, was simply to update 30-year-old guidelines that not have the binding force and effect of law, and try to faithfully capture Title VII law.
No, this is equal pay.
I'm get there.
Okay.
The California Equal Pay Statute Amendment that has gotten much notoriety is now going to become legally effective in California in 2016. And two of import to practitioners that may influence what OSCCP has done on its pay report. No one really knows. That's the rampant speculation. But it's probably pretty good speculation, because what we've seen consistently is that the California guys are driving decision-making in Washington as to policy matters on OSCCP and on discrimination law generally. The Equal Pay Report Amendment the Equal Pay Act Amendment in California does first changes the federal equal pay standard, that the federal standard only applies to each establishment. In other words, you compare some situated employees, men and women, in the establishment. The California Amendment, when effective in 2016, will allow a plaintiff to compare employees across establishments within the same company, but in different establishments, somebody in San Francisco and somebody in San Jose, for example. The second thing that it does is to broaden the standard to say substantially similar employees and not similarly situated employees. Now, I'm not at all concerned about that. I've seen a lot of blogs about this, but that is the federal standard. The federal standard for the last 40 years has been consistently interpreted by the federal courts to say that substantially similar people, employees, or applicants are the ones that you compare. So that's the story on the sex discrimination guidelines in relations at OSCCP and the Equal Pay Amendment in California. He has also asked about the Equal Pay Report.
No,
oh, sorry, go ahead, Candy.
No, I think you misunderstood me. The question was about the Equal Pay Report prognosis.
The Equal Pay okay. Well, there's another question. I'm sorry, I misread which one I'm talking to. The Equal Pay Report is probably dead in my mind for two different reasons. One, the annual regulatory agenda punted to next May of 2016, when the May 2015, 7 months ago, some annual regulatory report predicted that it would be in November of this year. Well, why is that important? It's been punted by a substantial margin. You heard me say, I'm sure, before that I never get concerned about OSCCP in any administration missing a date by a couple of months or even by 5 or 6 months. They can never tell. They're always overly ambitious, and these are very complicated procedures within government, and delay should be expected, not to be held against OSCCP. But have a double punt like that, where you've punted it 6 months until the fall of 2015, and then you punt it to the spring of 2016, which coincides with the next semi-annual regulatory agenda. That's usually a trail sign that there is not, in fact, a specific target date intended and on the books ready for publication. Currently, CCP is in talks for the last several months early with the EEOC, which has studiously been following the National Academy of Sciences' 6-part recommendation on developing an equal pay reporting database. As you'll recall, in 2013, the National Academy came up with a searing review of the EEOC and the OSCCP's proposal do something like an equal pay report and said they weren't ready for it, they didn't have a proper plan, there wasn't enough confidentiality, many, many other criticisms about a panel at the National Academy of Sciences that was packed with pro-OOCCP, pro-plaintiff economists. In fact, concern was at the time that the contractor community was going to get blindsided by this very pro-plaintiff, including the Walmart plaintiffs, labor economists who was on that as well. But the point is that EOC buckled down and listened carefully. OCCP proceeded what I would suggest was, frankly, recklessly, and forward with an equal pay report that most of you commented upon made no sense and was not going to further the aims and ambitions of OCCP. I think it's probably dead, but we will have to see. But I think there's a lot of trail signs suggesting that the OCCP is going to get in bed and on board with the careful process that the EEOC is now going through. Probably another 2 or 3 years of that process ahead at the EEOC.
Okay, thanks, John. I feel a whole lot better because I could not figure out why he was going on and on about the California equal pay and sex discrimination, but that was the third question, and you saw that one, so I feel better now. We've already received this question a couple of times. What is the status of Executive Order 13673? Should we expect to see anything soon? And someone else asked for the blacklisting prognosis. So what do you think about that one?
This so-called blacklisting regulation, I don't tend to call it by that, but that's its handle in the marketplace right now. It's technically known as the Fair Pay and Safe Workplaces Act, an executive order that the President published directing the Department of Labor. I did not say OOCCP, the Department of Labor, and simultaneously directing the FAR Council. The FAR Council is made up of the 3 largest contracting agencies that procure most of the federal goods and services. That's NASA, Department of Defense, and the General Services Administration. So the 3 of them are the big hogs at the table, and they write the government contracting regs presumptively on behalf of the whole federal contracting agency, a collection of federal agencies that buy things in the marketplace. And both of those units, the FAR Council and the Department of Labor, to come up with regs in 2016 to be effective in 2017 would require bidders on federal contracts to provide extensive amounts of information in response to labor compliance, 14 different statutes, OSHA, NOWR, and including OOCCP's 3 statutes that it enforces, the Executive Order 11246, Section 503 of the Rehab Act, and VEVRA as to protected veterans. The idea was that they would create some advisors in each federal agency under direction by the Labor Department as to when to deny a contract to a prospective bidder and when to deny a prospective successful bidder, use a subcontractor that contractor was proposing to use on a federal contract. It's what I'd call a labor purity standard that was now going to be introduced to deny contracts. This Chamber of Commerce's #1 target legislatively to stop. They stood successfully, as you may distantly recall, in the waning days of the Clinton administration when a similar proposal came forward from the Clinton administration. Democrats are very concerned about this. This is not just a Republican issue of companies, because there's billions that we're talking about, tens of billions of dollars that are at risk here if federal contracts are starting to be denied. So the whole government contracts bar is exercised on this, and not just the labor and HR community. So there's going to be a major tussle, but the prediction of the Labor Department is that these will come out in the spring. I strongly doubt that. I've been in touch with the FAR Council. They're very sturdy lawyers, very sturdy administrators. This is serious business over there for them. They received overwhelming volume of comments. They won't give me a precise date, but it certainly sounded like it was a year away. That's my read of their response to my inquiries about where they are in the traffic pattern. I want to say one last thing, and we'll get on to the next question, and that is that the federal contractor community should not worry a moment about the regulations should they in fact go to final, whether in April or whether it's before January 20th of 2017, when President Obama leaves office. And because the federal contractor community has already litigated and won these issues 16 out of 17 times back in the Carter administration. Carter administration attempted and did debar with a formal hearing federal contractors. And finally, they lost so often and so vehemently with judges accusing the Department of Justice and OFCCP of being extortionists. The Labor Department was forced to withdraw their being debarments. We should also remember, as a final thought on this, that the Executive Order 503 in VEVRA expressly state in black and white that you cannot be debarred without a hearing, meaning a trial-type hearing that goes to an administrative law judge and then goes to appeal. In this case, it would be the Administrative Review Board. So that would take, at best, 2 or 3 years if everything was moving like clockwork. They cannot deny you a contract without that full trial-type hearing under at least those 3 statutes. OSHA, Wage Hour, Service Contract Act, Davis-Bacon, etc. That's all different. They don't have the kind of contract statutory guarantees. Those statutes, litigators will be filing suits, I guarantee you, under the process clause of the Constitution, because the courts have also held that those files of contracts are subject to the due process clause and require trial-type hearings before you can deprive somebody of a contract.
This is an interesting one. Last EEO-1 required that we combine individual entities that are in the same physical location, even if we previously reported them individually. It created some 50-plus locations we have, for which we have never done AAPs. Do you think we need AAPs for these? I've heard this a couple of times.
Okay, so this is kind of an interesting behind the curtain stuff. Let me give you one piece of background before I answer the question, and it'll be more meaningful to you. The reporting committee doesn't exist. That's the entity, the fictitious entity, to which you send your EEO-1s every year. The reporting committee is a budget line item in the OFCCP and the EEOC budgets, and they, in turn, defer to the EEOC as the agency on the EEO-1s, and the EEOC has a team of people who, with OFCCP's consent and participation, retain a data processing company, typically down in Norfolk, Virginia, where there's a large cluster of data processing companies. And they call the EEO-1s, and they convert them to digital form and deliver them back in digital readable form to the EEOC and the OFCCP and other interested federal agencies. The Joint Reporting Committee, without telling you, for 2 decades has been combining all of the subsidiary corporations of a corporation by using their D&B number, their Dun and Bradstreet number. So you might think that the parent corporation, for example, let's admit it's the one that's federally involved and has a covered federal contract, and you checked on subpart E as in Charlie of your EEO-1 form that the parent company has a federal contract of $50,000 or more, and the company has 50 employees and is not exempt under 41 CFR section 60-1.5, causing you to go into OFCCP's audit pool. That's the design that I created in 1982 at OFCCP to create the audit system that is used today. So all subsidiaries have that same D&B number as the parent. So the Joint Reporting Committee has done, in fact, for decades, is to consider all of your subsidiaries to be a single entity, meaning that they're all the same company as a matter of law. And that's why OFCCP has, for decades, attempted routinely every year to audit subsidiary corporations that did not have any federal contracts. And many of you would assert that the subsidiary corporation that was being audited had no federal contracts and was not under the control of a parent or under the control of any other subsidiary which did have a federal covered contract or a covered federal subcontract. And if you were smart, you would raise your hand objecting to OFCCP after you read the notice of desk audit and say, we just got audit letter, the audit scheduling letter, but we're not covered even though our parent is or even though one of our other subsidiary sister corporations is, so we ask you to administratively close the file. OFCCP would then send out, almost always, 99 times out of 100, the so-called famous 27-point questionnaire. Lousy document that I attached to a letter to a major law firm in 1982 inquiring about when OFCCP would consider two separate companies, a parent and a subsidiary, for example, to have to submit to audit and prepare AAPs. And I explained that we had to go through a single entity analysis, and I attached a document that was lying on the desk in the policy division that was developing questions for compliance officers to use in audits to get the facts, FACTS, and whether the two entities, parent and sub, were sufficiently closely related. You want to write that language down because that's the legal test. Sufficiently closely related that one would say that the two entities, parent and sub, in my example, were a single entity as a matter of law, even though physically separate and separately incorporated. OFCCP has used those 27-point questionnaires to date to get that information and make a legal decision as to whether they could audit the sub, in my example, that does not have a federal contract and is assertedly not controlled by the parent that is federally covered. What's happening now is the Joint Reporting Committee is asking you to consider all of your subs a single entity. Don't be taken by that. That's different than what's been happening for 20 years. But what you need to do is to remember that if you do believe that one of the companies that's being audited is not properly a covered federal contractor or not properly a federal covered subcontractor, you need to raise your hand, object in a polite and firm way, a letter to OFCCP when you get the office, the audit scheduling letter, and tell them we're not a single entity. OFCCP will send out the 27-point questionnaire and investigate. Final comment, that if you do have a company, whether a parent or sub, that is federally covered, a direct prime contractor or as a sub, and you do have establishments that are under 50 employees, you need to develop AAPs for that establishment. All the other coverages are there as well, even though they only have 10 employees. That's been true since 2000. You will be pathetic little AAPs, but they will nonetheless be AAPs. But you have to understand that in the Clinton administration, as they went out of office in 2000, they said that every employee has to be in an AAP somewhere. Where you put them is a series of 4 complex rules beyond the scope of this discussion today. But I think you have the total picture of what's happening with OFCCP's audits. They're presumptively assuming that conglomerate companies are single entities. It falls to you to explain it to them and convince them to the contrary.
One thing, a couple of clarifications I want to make. I'm seeing a lot of questions about the format of the web today. We are going to take questions, answers for the first hour. I think we had advertised that we would do the webinar first and then the questions and answers. We're doing the Q&As first, and you should only see the title slide right now. You're not missing anything. We have not moved. We have a nice PowerPoint, though, to present to all of you. But just tight and ask any questions that you answered right now, and we will go through those. And there was one thing I wanted to cover. Any questions, Casey, that you're seeing that we should make sure we cover? So it was just the order that we're doing. The Q&As first, then the webinar, and you should just see the first page of the
We wanted to give you a chance to ask all these questions that we constantly see in whatever seminars we see, that people feel like they never have enough time to ask questions, so we open the floor to that. And
John, there was some clarification. I think you started going down a different road with the question last time. She said that those weren't subsidiaries, and you were talking about them being subsidiaries. She's seeing on the EEO1 that they want 50 plus. So they're individual wholesale warehouse locations. So bottom line, do they need to do AAPs now, yes or no?
If federal, you're covered as a federal contractor, you're covered as a federal subcontractor. All employees, whether they're in establishments or 50 or more, have to be in AAPs at least since the year 2000. That would change from the old days where we didn't have everybody in AAPs. Yeah, that's a straightforward question. Now, the reason most of you are surprised by that, and I find constant surprise about that, is the OOCCP has also had an unrelated rule that was created in 1983 that is still being enforced, except in 2013 and except in 2014, said, just an unofficial internal rule at OOCCP, that for 25 years, that the OOCCP should not audit below 50 employees because nobody thought it was worthwhile to do so. The administration wanted to test that, even though, 5 minutes of OOCCP before that thought that this made sense. After 2 years of testing it, they realized this does make sense, and they have reverted, without telling you, they don't have to only auditing above 50 employees in an establishment, even though they have the right and retain the discretion to go below the 50 employee threshold and audit a facility of 10. Now, I've heard tell of only 1 or 2 establishments below 50 that they've chosen to audit during fiscal year 2015 that just ended. It happens, but it's aberrational. It was popular for them to audit below 50 in 2013 and 2014, but that seems to be over now.
Okay, so this one's interesting. I submitted my EEO1 reports in October, and they have yet to be uploaded. Our company has 88,000 employees with over 500 locations. You have my sympathy as far as putting affirmative action plans together. I reached out to them multiple times and was told my reports were not late and they will get to them. Have you heard this?
Same reports from a number of companies, and what seems to be common to them all is they are very large companies reporting tens of thousands of employees.
Which is what
I've not heard such a report from companies turning in reports of 3,000 to 5,000. The smallest I think I've heard of was 38,000. That's just a technology problem that the Joint Reporting Committee will, I'm sure, soon overcome.
But, all of our confidential compensation that they want will definitely be safe when we have all of these technical problems. Okay, so there was a question on the minimum EEO tagline. Is it EOE or EOE vets military? And EOE at least have vets and military in there. EOE will cover males and, males. I had somebody tell me they thought M&F was female, minorities and females, but you have to at least address vets and this says they put it in vet/military, but veterans and disabled or disability or whatever version you want to use, but it cannot be V and D.
So the opportunity will cover everything under the executive order, including the new transgender, LGBT rules for gender identity and sexual orientation. So DOE takes care of all executive order requirements. And then if you're covered by 503, you would add individuals with disabilities or disabled. Either those will work. And if you are separately covered by VEVRA, and I want to remind everybody that as of October 1st of 2015, a month and a half ago, suddenly, without a whole lot of fanfare, that the threshold for VEVRA increased to a contract of $150,000. Now, you are not covered by that. The government estimates 76% of you are not covered by that. So it could be that you now have a checkerboard compliance responsibility under 503, yes, executive order, yes, but VEVRA, no.
But can you, how many people can find those contacts?
Right, that's another problem.
Anyway, just one additional clarification, and the question was related to the minimum EEO tagline, but I've actually said this a million times, and I still get the question. The time you have to use sexual orientation or gender identity is if you use the word sex in any tagline. So if you have a paragraph form of a tagline or whatever, anytime you have race, color, religion, sex, national origin, whatever the grouping that you use, if you use the word sex, you must add sexual orientation and gender identity. I do want to address the fact that we have several questions already about veterans, and we will cover those. I've actually written them down so we don't miss them, but we're going to hit those during the Protected webinar.
Okay.
You provide updates on healthcare in light of the UPMC Braddock and hospital case?
Okay, let's just rack this up. I get this question a lot because everybody's confused about healthcare. And it's a little bit of a tricky story, but here's the skeletal outline. There are many clinics and many acute care hospitals that sign direct federal contracts with the government. For example, hospitals are signing Bureau of Prison contracts because the Bureau of Prisons is outsourcing a lot of its medical work. It is closing its prison hospitals. I have many hospitals and clinics telling me that they are picking up outpatient work in their emergency rooms for many federal prisons. Second arena is psychiatric services and orthopedic services for returning veterans from the Middle East. The United States Army is considered the best orthopods in the world at building limbs in light of the experience we've had in the last 20 years in the Middle East. Are tapping out of capacity, and so they're reaching out to a lot of hospitals now and signing contracts for orthopedic services and rehabilitation services. They're also reaching out to a lot of research components of hospitals, particularly university-based hospitals, do work about advanced computer operation of artificial limbs. So we're seeing those contracts come in. On the psychiatric side, the Army in particular feels like it does not have as deep and as good a cadre of psychiatric services available, and the PTSD and other related syndromes coming out of the Middle East is causing the Army to increasingly hire psychiatrists and psychologists from the hospitals. So they're all going to be signing direct contracts typically for that. Now, next thing that affects the hospitals is that the Office of Personnel Management buys health insurance for its employees, and they've done that in a variety of different ways over the decades. Currently, they are signing direct federal contracts with some hospitals. Others they're doing through TRICARE. So let's talk about TRICARE. TRICARE is a $6 to $8 billion a year program that the Department of Defense operates through regional administrators to provide medical supplies and medical services to retired personnel from the DoD, which have those rights for life, and increasingly to some active duty members in locations where there is not a hospital So you've got to look at you know, what they're covering, and then you've got the fact that care is on a 5-year moratorium. There's a hullabaloo from the hospitals about this. The Florida hospital, the country's largest hospital, filed a lawsuit objecting that TRICARE was not a contract. But taking you through all the turgid history, the two critical things to call are that the 2012 DOD budget contained a rider in it that made care from OCCP audits while admitting that it was a federal contract. Solve that situation, at the time the Democrats and Republicans were poised to codify that rider into the form of a statute that would prohibit OCCP from auditing TRICARE contracts. Secretary Perez, new in the office at the time, approved the House the House Labor Committee, and posed a 5-year moratorium that not audit hospitals, even though they were federal contractors by virtue of TRICARE. And that caused enough Democrats on the House committee not to vote in favor of a ban on OCCP audits. So you currently, as to TRICARE, of a 5-year moratorium, but OCCP promises to spring back up in years and start auditing the TRICARE contracts. They are in a period of what they consider technical assistance in the meantime, helping hospitals to understand how to comply.
Okay, thank you. Is this acceptable, or do they need to add in sexual orientation and gender identity? This is a new one, but we have an answer for you. EOE-equal opportunity employer. People of color, women, veterans, and individuals with disabilities are encouraged to apply. No, don't have to add in sexual orientation and gender identity because they have not used sex. And people that are people of color and women and veterans and individuals with disabilities can be white, green, yellow, or purple. So I mean, that covers it, and the EOE is the critical piece in that situation. So, and this is actually, I'm just going to do a shout out. I'm not going to say the person's name, but this was very good. It says on the OFCCP website under the Q&A for Executive Order 13672, it says that the contractors may either state that they do not discriminate on any of the protected bases under, and if you pay attention, it's EO 11246, so the Executive Order for Females and Minorities, and list them all, or they may simply use the phrase equal opportunity employer. So that's what John had just clarified. So I appreciate the fact that they did some research as well. So we have the VEVRA pre-offer form is I'll just see what. The VEVRA pre-offer form is no longer required. If this form is no longer completed, how do we determine our veteran applicant pool? I haven't heard that.
No, that's an erroneous report. You still have to, by regulation that went to final March 24th of 2014, the final VEVRA rule says that you have to make an inquiry pre-offer and post-offer. What you have undoubtedly heard in October of 2014, the Veterans Employment and Training Service, about whom we'll speak much in the second half of this program, decided that they did not want to have a report of the price numbers of protected veterans in each of the 4 categories of coverage. They had, as you'll recall, in the Vets 100 report and the Vets 100A report, you had reported how many recently separated, how many disabled veterans, etc. They changed their minds when they published the Vets 4212 form in October of 2014, which you used for the first time this past fall of 2015 to report your veterans, and you were only required to report the head count. Yes, have X many protected veterans, without telling you how many, tell the government how many in each category. So Pat was on my Nellie Affirmative Action briefing speaking in San Francisco in 2014 as this new development unrolled and unraveled. And I asked her whether it was their interpretation, as it was mine, that contractors could nonetheless exercise their discretion if they wanted to, as many of my clients were saying they wanted to, and for the universities, I might add, to ask post-offer employment. I did say pre-offer. I said post-offer, pre-employment, whether the contractors could ask which kind of protected veteran you are. And she answered yes. Contractors could make that inquiry post-offer, pre-employment if they chose to do so, but OSCCP was not requiring it. ETS was not requiring it. By the way, just keep this in mind for the second half of this program. The OSCCP definition of protected veterans relates to the definition that the Veterans Employment and Training Service defines, and I'm going to show that to you in black and white in a moment.
Okay. Sounds like an interesting job. I'm a risk steward for an HR-related questionnaire sent to our third-party suppliers. A number of these, mostly law firms and small to mid-sized employers, have responded that they do not have AAPs. Should I assume that they are not government contractors?
The absence of an AAP doesn't tell me that they're not a federal contractor. They may or may not be. The administration surveyed this and found that 70% of federal contractors did not have AAPs. I have not seen a subsequent survey, but my personal observation has been that at least 50 to 60% of the covered population does not have AAPs in place and ready to go. And SHU has indicated as recently as our October 2015, 2 months ago, Nellie Affirmative Action Briefing, the greatest problem at OSCCP with contractors is their failure to timely deliver affirmative action plans in response to the 30-day audit scheduling letter, again evidencing that even with the CECL letters, the corporate scheduling announcement letters that give you advance notice of audits, that you still do not have your AAPs ready to go as we expected when that audit letter arrives.
Okay, it's kind of interesting based on some of the conversations we've had at my office today, and people were asking John almost the same question. How do you square the recent ALJ jurisdiction-related decision in Convergys with older Bank of America decision? Convergys requires I like this, he used the letter K for contractor, to supply the desk audit materials while jurisdiction is being contested. But Bank of America indicates that a contractor waives the right to contest jurisdiction once desk audit materials are submitted. Good question.
That's a good question, and it's a complicated one. I'm going to cut through pretty quickly without going into depth in Fourth Amendment law that would take up too much time. But the short answer is that what the ALJ, the administrative law judge, held in the Convergys case that was just filed shortly ago, and the chief ALJ, Stephen Handley, handed down an immediate decision saying that there was jurisdiction despite their Fourth Amendment objection. Convergys has appealed that, I see. I don't represent them, but I see that they have appealed that to the Administrative Review Board. The Bank of America decision in the Administrative Forum and in the Federal District Court in Washington, D.C., had held that if you want to contest jurisdiction under the Fourth Amendment, the contractor needs to not deliver documents in response to the notice of desk audit, because if you do deliver them, you waive your Fourth Amendment rights. BANCA had successfully proven in federal court that OSCCP had violated the Bank of America's Fourth Amendment rights, but they then said, I'm not going to rule in favor, ultimately, of Bank of America because they waived their Fourth Amendment rights by having tendered the audit materials to OOCCP. They rather should have withheld it and bubbled up a lawsuit by calling OOCCP to file a complaint in the administrative forum, as OOCCP has now done with Convergys. So Convergys is doing the right thing to pursue their Fourth Amendment claim in the first lawsuit involving 7 establishments that are at issue that have not provided AP data. They're bubbling up the Fourth Amendment issue in the proper fashion. They're going to get to federal court eventually, after they probably will lose in the Administrative Review Board, which candidly has not been issuing neutral decisions for a number of years now. They always tend to favor OOCCP. So I dare say and predict that Convergys will have to go and be patient to get to federal court before they get a neutral judge that will determine the quality of their Fourth Amendment objection.
The one thing I've always said, I have horror stories that I could probably share, but just a good piece of advice for federal contractors, and not even at that level, but when you give something to the OFCCP, it's theirs. So, I mean, they can do with it what they want. Okay, so this is an interesting question, and it says, if a contractor entered into a conciliation agreement prior to October 15th for good faith efforts for vets, and no longer a covered federal or a covered VEVRA contractor, do they still need to report the vet's good faith efforts portion of the CA? First of all, I'm going to answer one piece of this. I would like to think that they never signed a conciliation agreement for not showing good faith efforts for vets, because it's not a requirement for veterans or VEVRA or for in 503. So that's where I'm real careful about calling the OFCCP out when they try to cite you for something that is not a requirement in the regulations. But do they still report that conciliation agreement?
So context is they've signed a conciliation agreement when they were a federal contractor or subject to the federal contract that then ended. And they do not have currently in force a federal contract or covered federal subcontract. There is no case law on that specifically, but I believe fairly strongly that this company would not have to continue to honor its conciliation agreement. But this is dicey. Here are parts of the law. There's a line of cases that's called OOCCP versus Priester Construction Company, Priester, Priester Construction Company, that holds for the fact that once the contract is over, it's over. You have no forward obligations. They can hold you accountable, though, for what was done during the contract. They can look backwards, if you will, during the period of the contract, and if you discriminated, for example, they can make you pay back pay and cure it, even though you don't have that AAP or that jurisdiction today. There's another line of cases that says you have to honor your contracts. And that's what OOCCP would argue here, is that you have to play through. Unfair, they would argue, to the other federal contractors that spent money and comply properly with VEVRA, and so to make sure that the federal contracting field is level and you're not getting away with providing the goods and services at a cheaper rate, they'll hold you to that. Culture in the Clinton administration was very keen on doing exactly that. They would enforce contracts that were closed, but the tradition since then has been to just walk away from these things because there's no utility in it. But that's because OOCCP has largely exercised its discretion to do so, because OOCCP likes to fix systems. And if there's no systems in the future that they can affect, they typically don't care. They would have to enforce the jurisdiction here and argue that they need to level the playing field. With the judge, I could win that case, I think 7 times out of 10. Afraid of forum, it's done these days. These judges are candidly not being terribly fair, depending on the judge that you draw. Litigate this case over a technical affirmative action issue? Probably not.
Okay, just one back. This is a quick answer on this one, because I have a question that is your very favorite topic, and I want to make sure we get to this. But this relates to the Convergys question from earlier. How does the Convergys ruling impact those federal contractors that have Convergys as a subcontractor? Short and sweet.
Convergys a subcontractor. Well, if they're a subcontractor unto you, it doesn't affect you at all.
Right.
It could in the future if the Fair Pay and Safe Workplaces blacklisting so-called rules go into effect, because you'd have to shed them or be deprived of your contract.
Okay, this is your favorite topic, and we're going to do a layman's term answer. So I heard references to adverse impact analyses, and discipline analyses. Are those all the same, or how are they truly different?
They're all very different. Let us review the bidding. This is discrimination law discussion now. And in discrimination law, there are theories. One is disparate treatment, and one is disparate impact, or what is often called adverse impact. Those are terms of art. What happens with lots of law firms, with lots of HR consulting firms, almost uniformly within OSC, they can use the term statistical disparity with adverse impact. In other words, anytime there is a statistical disparity, they call adverse impact. They should not do that. Impact is a very unusual analysis in OCCP land. OCCP almost never undertakes adverse impact analyses. Rather,
They do, though.
Because they confuse the two terms.
Like listing and posting.
Yeah. So, in 41 CFR section 60-2.17, B as in boy, 2 and 4, it would tell you that you have to undertake disparity analyses for hires, promotions, and terminations, meaning involuntary terminations. And I mean by that is disparate treatment class type analyses. We put all of the applicants into an analysis, all promotions into an analysis, all of the involuntary terms, and the time frame for OSCCP is the year prior to your AAP. Now, why is that an adverse impact analysis? It's adverse impact analysis because an adverse impact analysis looks at neutral, specific policies that are not intentionally discriminatory. Not intentionally discriminatory. The analyses look at all selections made, all rejections made, whether they've got to be intentional, regardless of when or how made, as long as they're intentional. So what's an example of a neutral policy? My favorite, of course, is what's most popular at the EEOC these days, background checks. Does OCCP get involved in background checks? It does occasionally, but not mainly. So say I have, to illustrate the point, a third process. I have a phone screen, then a paper and pencil test, and then I have a background screen. What OCCP wants you to do as part of your disparity analyses is to put the result of all three activities into one statistic. Hire that applicant or not. If you're doing adverse impact analysis, you would not do an adverse impact analysis on anything but the test, the second part of the battery that you confronted this person with, because a specific neutral policy not intended to discriminate based on race, sex, religion, or any other covered status. You would take an adverse impact analysis separately, not as part of the test, but for background check, because maybe African Americans, whites, Hispanics, etc., pass the test, but may get excluded disproportionately because of the background check, which, by the way, will happen close to 100 times out of 100 with African Americans and background checks, hence the EEOC's great concern about it. So there you have a different set of proof you have to put forward in response to that adverse impact analysis. That exclusion that's disproportionate because of the background check. I didn't say the test. I didn't say the phone interview. Prove your business need to have that exclusionary effect. Some of you will win that. Some of you will lose that, depending on the job. You know, obviously, if the job is a teller job at a bank, and you've got somebody who failed the background check because they're a thief or a burglar or other related character issues, not going to be a proper hire for the bank. The business need will be demonstrated, and you'll win. But the disparity analysis under 217 is in boy 2 and 4, you're going to put all of those applicants, all of those rejections for each of the 3 components of that battery, the phone screen, the test, the background check, in one statistic, not statistics. Well, you're going to spend a lifetime, everybody straight on listing and posting.
Yeah.
It's clear to me that I'm going to spend a lifetime getting everybody to understand the differences. Now, let me answer the last part of this question. What is an IRA analysis, which is what OCCP records? If you look at their data sheets, they're doing classic disparate treatment class-type analyses. And they're not doing adverse impact analyses. They could, by a specific neutral policy being written, or do it by looking at a specific neutral practice, but they rarely do. We've only seen 2 adverse impact cases as lawsuits at OCCP in the last 25 years. We've only seen them aberrationally in audits.
Okay. Well, that's about, just for everyone's knowledge, that's about the quickest discussion I've heard him make on adverse impact, disparity analyses, and impact review analyses.
Well, and I promised the Valley Affirmative Action briefing attendees that next year we're going to spend a marathon on adverse impact with examples and when it's a disparity analysis, when it's an adverse impact analysis, and so forth, because, boy, I see a lot of blogs routinely that are just wrong on this and just don't understand discrimination law. By the way, for the lawyers, Teams versus U.S. and U.S. versus Hazelwood, May 31st, 1977, are your cases that gave us the disparate treatment class-type disparity analysis cause of action and set out the proof. Who are interested in adverse impact, that came from Griggs versus Duke Power in 1971.
That's uniform guidelines as well.
Uniform guidelines attempt to interpret what you need to do a proper adverse impact analysis, not a disparity analysis.
Oh, one last question before we start the webinar, and this should be, if a director missed a female minority goal and did not document good faith efforts, resulting in a conciliation agreement for failure to conduct good faith efforts, is CCP entitled to progress reports on applicants' hires across the establishment for reporting, or only for the job groups with missed goals?
This is unclear, but the tradition has been the progress report is designed to show compliance with what failed. So if you failed the good faith effort demonstration as to one goal, one job group, there would be no cause for OCCB to be concerned about your other 10 or 15 or 20 job groups. That's overkill. But lots of compliance officers trying to, what I call, steal first base and stretch and grow their progress report to turn it into a mini audit in the future, but have always been successful hundreds of times in pulling OCCP back by come to recognize what was the error. We're trying to fix the error. There's no need to fix things that aren't broken.
Okay, I do have one more quick question, and I think I can answer this. We have received several DOL news releases over the past few months regarding OFCCP activity. Would you say that overall activity and findings are up, or are they just doing a better job of publicizing their wins? And I would say that there is probably one of the worst years as far as the number of audits and the number of findings, and that they really are just trying to boost the publicity, I think. Normally what you hear is that a $50,000 dollar limit is kind of what they use to gauge whether they're going to have a press release about it. But would you, John, that it's just more we're in a situation where they want to publicize what they have been doing.
Emphasizing every discrimination finding and every lawsuit. The level is way down. This was the worst enforcement year in the history of OSCCP in FY 2015 that just ended October 1st. I published all the statistics in the Nelly Affirmative Action Briefing. They're somewhere between 30 and 50% down, depending on what metric you looked at, whether it was back pay collections, number of systemic cases. There were 7 total compensation allegations in audits, not lawsuits, as to compensation. 7. Not 70, 7. They did 2,603 audits. They're supposed to do 3,900 to 4,200 by their estimates. 4,000 is what they've always achieved year in and year out. They just fell off the cliff last year because they were so focused on regulatory reform, and they're so bollocksed up going with, as they've promised in in budget documents, to do very deep, very fine lines in audits of compensation.
As promised, we're going to get started with the actual webinar, and as I said before, we had a few questions related to protected veterans. I have them written down. I won't forget them, but I think a lot of your questions will be answered during the webinar. So, again, I'd like to present John Fox. He is the and he's been doing a lot of research. We had Pat Shue at Nelly in Chicago, and there's a lot of things going on with the den of protected veterans, either during a war or during a period of war, and then 2 FAQs came out, and John's going to address all of this and what the actual effect is on the federal contractor. And bottom line, we're going to give you practical advice on what you really need to do. So there you go.
Well, thank you, Andy. This has been really fun to watch unfold because it's one of the oddities that has played out in public in large part, but I'm going to take you through this agenda. I look at us having been in a webinar for the last hour, by the way, Candy. We had a question and answer component. Now we're going to do the PowerPoint component. I don't equate webinars with PowerPoints. I do a lot of webinars without any PowerPoints. But that's what the issue is. Then I'm going to tell you about OSCCP's changed definition of one piece of the protected veteran status that's called during a war. I'll tell you that OSCCP claims that it did not change the definition, but I'm going to tell you candidly that's hooey. Lawyers love to have fun with words, and this is what we're going to get into. It's one of the more fun things we do in Washington. Then I'll tell you, because I think it's important for you to understand how much bigger the definition is, because it's big. It's 3 million plus, probably, no one really knows, veterans that are being brought into the definition of protected veteran. And then I'll tell you what you do with vets, the Veterans Employment Training Service that runs in parallel in this regard, because they require reporting under 4212. Now, as of the last reporting period, using the VETS 4212 form, I assume you all know that the VETS 100A and the VETS 100 forms are withdrawn and no longer in use. Then we also have a third thing we have to worry about, apart from OSCCP, and what do we do with our effectiveness reviews under the Protected Veteran Statute, apart from our data metrics, apart from our self-ID forms, apart from the VETS 4212 form. So the Secretary of Labor has authority under VEVRA to receive directly complaints from protect veterans if they think a contractor is failing any of its duties. They're filing the VETS 4212 form or in developing its affirmative action plan. And I want to give some comfort if you had a complaint from one of these newly covered veterans under the expanded definition. If one of these 3 million plus files a complaint against you and realize that this is the largest part of OSCCP's complaint docket, they will be able to argue OSCCP they should dismiss it without you having to offer a single piece of evidence because they don't have jurisdiction. So I want you to know why OSCP and VETS is in error with their expanded definition. Then we'll get to the practical piece. What do you do? And in advance, probably, and we'll find this out in this webinar because I'm going to do some polling on this, we're probably find out that about 90% of you will do nothing different tomorrow than what you're doing today. So you can relax and be calm right now. There's 10% of you that in your discretion, I think will find out, maybe it'll be 20%, I'll be very interested about what this percentage is. In your discretion, do something more than you have to do, and want to exercise your discretion to expand your definition to capture these new 3 million plus veterans that are in the system. And then I want to remind you, this doesn't really matter. There's a tempest in a teapot, as I've called it, for a long time now, because it doesn't change your compliance obligations one iota. We'll see that unravels and unpacks, because that's kind of an interesting story to understand what happens. Key, I wanted to bring to your attention the term during a war. That's a term, and a period of war, that's a different defined term. So you have to be kind of attentive to these words, because words mean things to lawyers. Then let's down to VETS, VTS. That's the Veterans Employment and Training Service. The people who write the rule, the regulations, I use the word rule formally. Regulations is street talk to describe a rule with a capital R, the regulations that you comply with. But the VETS rules require you to file the VETS 4212 form, and has definitions of protected veterans that you have to think about in parallel with what's going on at OSCCP. But that's not OSCCP. VETS is Separate Assistant Secretary of Labor down the hall from OSCCP. Okay, let's now get to what defines all these terms. That's 38 United States Code 4212, OSCCP's implementing regulations, which take that definition from USC 4212 and pour it into their regulations, similarly with the VETS, as we'll see. So 4 definitions that they gave us with the Veterans Act back in 2003, that OSCCP until 2014, yeah, I'm not kidding, 11 years to write regs that then caught up with what happened in the Congress in 2003, are these 4. Those who served on active duty in the U.S. Armed Forces during a war. And I'm going to give you the exact language in a moment. This is just my shorthand for it, just to get you the 4 categories firmly in mind. I'll give you the citations. It's VEVRA 38 U.S.C. Section 4212, E3. Remember that phraseology, because that's the first definition of during a war, 42A311. This review, I'll give you the detail in a moment. The OSCP implementing reg, doing care worth and providing that definition to you in its rule, is 6-300.2 B. Boy. They gave us the Armed Forces Service Medal Veteran, and I've given the VEVRA and the OSCCP citations to find that. Then, if I make the slide go forward, disabled veteran. There's the VEVRA and the OSCCP citations that give us those definitions. And recently separated veteran, and you know that in 2003 they changed the definition from 1 year to 3 years. You're a recently separated veteran if you were separated honorably from active duty within 3 years. You're a recently separated veteran, and there's the statute and there's the implementing reg. OSCP's implementing regs are very faithful to the statute. There's no problem there. The statute and the regulations both have the binding force and effect of law. Now, they all use the during a war terminology. And use the citations, and here's the actual language now under the statute for VEVRA at 4012A3A2. Veterans served on active duty in the armed forces during war or in a campaign or expedition for which a campaign badge has been authorized. So that definition, which we use as shorthand calling it the campaign badge definition, category, better said, 2 different parts. It's who served on active duty during a war. In the alternative, if you did serve in a war, or in a campaign or an expedition. Campaign is a military term of art, An expedition is a military term of art. They mean things. You have an expeditionary Marine, perhaps. A Marine provision to survive on his or her own 22 hours without aid and support reinforcements. They've got their ammo, they've got their own food and water, and they live on the land for 72 hours before being relieved and reinforced. Expeditionary Marine is somebody who has been provisioned to survive on their own in the wild for weeks before reinforcements arrive. These are defined terms. Okay, so far, and we've got from the Veterans Administration and from DOD lists of what are the campaigns and what are the expeditions that have gone on since World War II. Defined legal term, and it means those military conflicts are declared to be a war by a joint resolution of the Congress. Joint resolutions involving conflicts that are less than wars, but for it to be a war, there has to be and everybody agrees on this, this is not controversial, for it to be a war, there has to be a joint resolution of Congress. The last resolution declaring a war, everybody agrees, was World War II. Now, there are no more World War I veterans left alive. Frank Buckle, the last World War I that died 6 years ago. We do 800,000 living U.S. World War II veterans, and I don't know that I've ever seen a number of how many are still working, but these guys are now, if you do the math, in their 90s at the youngest. My father was on the tail end of World War II and is 89 today. Not today, but next month. So most of them are out of the workforce, but there's still a fair number working. I see them in aberrationally in AAPs and audits from time to time. They're usually commented upon my client. Now, the OCCP rule, forget about the statute, let's drop to what the rule says. It picks up the during a war definition faithfully from the statute. Just no bill, I'm just giving you the building blocks to get to where this is out. Well, OCCP's complaint FAQ that's on their website today telling protected veterans who can file a complaint. Well, it's during a war. It faithfully picks up the during a war definition. I've given you all of that verbatim on slide 10. That should give you great comfort if you get a complaint from somebody who claims that they are a protected veteran during a period of war. Another definition we're going to get to in a moment, because they're allowed to file a complaint if they served during a war, meaning World War II, or if they are a campaign or expedition badge member. I've given you the rest of the detail on slide 11 of the CCP FAQ. Remember, the FAQ does not have the binding force and effect of law, but does remind us accurately that the Jobs for Veterans Act in 2003 eliminated all Vietnam-era veterans unless they were covered by an alternative definition because they recently separated or they got a campaign badge. Some did, some did not. Many did not. Tens of thousands did not. But eliminated Vietnam-era veterans. So hold that thought when we get to the during a period of war definition, because we're going to find out that they added the Vietnam-era veterans back in. Also remind us accurately in the FAQ that's currently up there and has been up there for years that many individuals previously categorized as Vietnam-era veterans will be covered under an alternative definition, such as recently separated is an easy example. So you have to look under all of the definitions, 4 categories, and there's ultimately 6 different definitions within those 4 categories. You complaint FAQ, so you've got it all in one place. It starts giving you the pre-Jobs for Veterans Act definitions, and then as you see in the last line, it is that the definitions apply currently after the GA definition in 2003, after November 1st, 2003. So same during a war definition currently and historically. Now, what about OCCP's recent 4212 rule that went final March 24th? it was published in the Federal Register September 24th, 2013, it specifically rejected a broadened definition, and it says that it's not going to cover a Desert Storm veteran, which I commenter had said we ought to cover under the definition of protected veteran, and said, no, we're not going to cover them because they're a Desert Storm member. They might be covered, however, under one of the alternative definitions because they're recently separated, or they got a campaign badge, as many Desert Storm guys did. Most did. Me did not. You'll find out that it's not every Desert Storm member, and that's why OSCCP, the Bush administration, said we cannot expand the definition to include Desert Storm guys, which is the Persian Gulf War, by the way. Upper Desert Storm was our opening offense in the Persian Gulf War in 1990. You're going to, when we get to during a period of war definition, that unequivocally 100% of Persian Gulf War veterans are covered. So we have OSCCP changing, we're going to see in a moment, currently what it said in September 2013. But I thought, because really going to be important at what, whether they have authority to do what they're doing, except as to those veterans that are going to try to file complaints that don't have the authority. All right, so that 14 just summarizes what I just said, that the Desert Storm veterans are not routinely covered according to CCP and its preamble. They're only covered under the alternative definition if they are. Here's what's given rise initially to excitement on this issue. When OSCCP a couple of months ago published this infographic, not for your benefit, but OSCCP says for the benefit of protected veterans to figure out who is a protected veteran and who can file a complaint. And they told them, and I had to break this into 3 parts because it's too big to go on the slides, but the critical part is the second part of the infographic. It appears online all as one piece. But you see the box. I've created the box. That's why in the right-hand column I say emphasis added. I put it to bring your eye to the attention where it says they're adopting the definition of during a war as being during a period of war as taken from 38 United States Code Section 101. No, it is not 38 United States Code Section 4212A3. So it's a different definition suddenly. I saw that and people began to discuss it. I asked Pat Shue whether they had indeed adopted the 101 definition. I don't have a dog in this fight one way or the other. I like to be a commentator, tell contractors what they have to do to comply one way or the other. So I asked her. She happened to be coming the following week to my Chicago Nellie affirmative action briefing, and it among the first questions that she received, and said flatly, I had warned her in advance about the question and asked her to, prepare an answer so that the contractor community could figure out if that infographic was a error or what it was. Was it some new philosophy? He immediately said 2 things that were important. First, said no in response to my question whether CCP was adopting the 38 United States Code 101 definition. She then, we have not expanded the definition. We're not at liberty to. The Congress set the definitions, not us. So that seemed to make the infographic not have any vitality and was an error. Then I started hearing from a group in Washington that they were, and within OSCP, that they were trying to, quote, walk the director back and convince her to change her opinion now. They wanted to go forward with this broader definition. So we've been waiting to see how this internal debate is going to unfold, and came out with new FAQs a week ago Monday that shows how the debate is going to go, and adopted the broader definition. First of the 2 FAQs, and I'm going to underscore some of them because you have to read carefully to realize that they're really tiptoeing around this very carefully, because I think they know well that they're out of bounds, but I think you're going to care. I think this is much ado about nothing, ultimately, as I'll suggest in a moment. But I've given you verbatim the first infographic, which you have to find, by the way, by going to the VEVRA portion of their website and then clicking on frequently asked questions, and you'll see a flag that's yellow and says new. You want it on their landing page. You've got to take steps I just mentioned. Go to their landing page, select the veterans component of the website, and then select frequently asked questions, and see these two new ones beautifully flagged for you to find. And they say infographic does not change these categories. So 4 categories, they are not changing. But they say, importantly, my emphasis added in red on page 17 of the slides, rather it clarifies. So that's their word, clarifies which veterans are included in each category of protected veteran, so that veterans will be able to determine as a practical matter whether they are protected by VEVRA. Here is the statement. They're talking to veterans. They're not talking to you. And I'm worried about whether veterans who are not entitled to be filing complaints against you have that right. They do not. It's only those who served during a war or got a campaign veteran are covered by one of the other alternative definitions. The second infographic, which I've given you verbatim, and they pick up language during a period of war, but they then define it to be equal to a war and during a period of war to be the same. Subverted during a war to equal during a period of war. During a period of war is defined in 38 U.S.C. 101, as their infographic indicates, and given you verbatim of their statement here, their FAQ, who that covers. World War II, the Korean conflict, all these in Korea, of which the 2.2 million still alive, are not picked up by the VEVRA definition at a 4212A3. They get campaign badges, most of them. They didn't get armed service medals. That wasn't created until 2 decades later. They might be covered because they're disabled from but most of them are not covered other than under period of war. Stop right there. What is period of war definition? Why is it different? It's different because the period of war definition is something that the Veterans Administration, not the Department of Defense, not the Congress created. The Congress codified this at 38 U.S.C. 101 to be those veterans who get certain pension benefits. Was not designed for you as a reporting tool, and it defines who gets veterans preference. If you were in World War II, in a Korean conflict, if you were in the Vietnam era, whoops, right there. Wait a minute. If you served during the Vietnam era, now covered under a period of war, Vietnam era veterans in the Veterans Act, unless they were covered under one of the alternative definitions. We just sat in CCP's preamble confirming that. Okay, we're going to live with this sleight of hand. During a war equals period of war. So here is the full verbatim 38 U.S.C. 101 definition that brings in the Korean conflict guys who are not covered under any of the alternative definitions, brings in everybody from the Vietnam era, 100% of them, even though the Congress ordered them out. We'll come back to why that is in a moment. And then everybody in the Persian Gulf War, meaning all the Desert Storm guys that the preamble said were only covered under the alternative definition. I give 3 notes to help unpack all of this. The Persian Gulf War is still in progress, according to the United States government. It began in February of 1990 and has not been concluded. It's not a war. It's not something that the Joint Resolution of Congress issued a war declaration, but it's still operating. The first action was Operation Desert Storm. Some of those Persian Gulf War veterans have campaign badges. Most do not. That's where 3 million pickup is coming from. In fact, said another way, veterans after February of 1990 are now covered under OSCP's program OSCP says through its expanded definition, because of this Persian Gulf War pickup. It's still in progress. The as I say, created it 101 for pension benefits and employment preferences, not for OSCP and not for vets. The ethics and the FAQs do not have the binding force and effect of law. That's why I think you can confidently argue to OCCP if a veteran files, a veteran of a period of war files a complaint that OCCP needs to dismiss it. Slide 20 just repeats my conclusion. They have equate during a war now with during a period of war. Don't worry if you haven't been using the expanded definition, you're going to be in trouble. I'm going to address that in a moment. But I want to first address how much bigger is this expanded definition. So, but a lot of pundits think that it's 3 million plus. You got 2.2 million Korean vets alone. You've got like 1.5 million Persian War Gulf veterans. You've got all the Vietnam era veterans who weren't campaign badge veterans and who weren't disabled. They're very different databases. Everybody agrees. So you have been reporting by millions if you have been using, as everybody has been, I think we'll find, the during a war definition and not during a period of war. I want to help you understand who gets picked up extra. So here is from 38 United States Code, Section 101 at slide 22, all of the kinds of veterans that are picked up by during a period of war definition. The Korean conflict, everybody in the Vietnam era, everybody in the Tonkin Gulf resolution. I've given you the dates because, by the way, most veterans don't understand any of this. This is veterans talk for purposes of pen benefits, and this is OCCP and VES 4012 reporting speak, but they remember when they served. They do know that they were in Tonkin Gulf between August 10th, 64 and January 12th, 1971. They remember they were part of the Lebanon effort in the 80s, or that they invaded Grenada. All of that helped them navigate whether they are covered by this definition or not, I would suggest.
But that's what everyone thought they were able to get rid of. It was all those definitions.
In Gulf War, as I mentioned, Afghanistan, several Afghanistan initiatives, and notice they are not contiguous. There are gaps. There's Operation Iraqi Freedom and, again, our Operation New Dawn. Those are all particular periods of war, though not wars. So come back to slide 22 and slide 23. If you are one of those who publish to your applicants, to your post-offer, pre-employment new hires, the definitions of each of these 4 categories. On a poll on that in a moment, because everybody does. But you are one of those who does publish all of the definitions. You want to publish all of these definitions on 22 and 23 to help those applicants and new hires to know, oh yeah, I should say yes because I'm one of those. Here's a discussion now about the Veterans Employment and Training Service Vets 4212 form. First, the OSCP rules that went to final in March of 2014 require that you make a pre-offer and post-offer inquiry, as we answered in the first half of this webinar. The site of that is 300.42. Also, separately, VETS requires contractors to annually report, as we mentioned, protected veteran headcount on the VETS 4212 form. No problem so far. Next, and this is what surprised a lot of people, the OSCP self-ID form, as I explained in the question that came up in the first hour of this webinar, follows VETS, the Veterans Employment and Training Services definition of protected veteran. So here's the OSCP rule verbatim for you as to post-offer. It's that you have to follow the rule at 41 CFR Part 61 Notice change in citation 61. That's where the vets rules are, and the rule that requires the 4212 filing, not CCP's rules. So OCCP's self-ID rule definitions and categories can piggyback whatever the vets says. And now I've been concerned, well, where is vets on this issue? The reporting statute says during a war, just like the OCCP stuff has said historically. During war, not during a period of war. But okay, let's stay tuned. Now changed its position in response to OCCP's changed position. So they're saying that for purposes of the VETS 4212 rule, that, you verbatim what they've told me, because this is so important to understand the dance that is going on here. Your VETS official, deputized to speak about all this on behalf of VETS, has said that we and OCCP interpret regs the same way. No, say the regs, and that's perfectly true. Their regulations pick up the during a war definition as good, and they say that they're not going to answer my questions about, well, are you saying we have to follow the 38 U.S.C. 101 definition, or what do I tell federal contractors? Do they follow the 42A3 definition, or do they follow the 38 U.S.C. 101? Is it during a war or during a period of war? Which do you want? And if you want the broader definition, does that mean we have to go back and correct all of the VETS 4212 forms that we just filed? And for that matter, what about the VETS 100A forms that were underreported for these many years? So VETS has concluded is support OCCP's infographic and 2 new FAQs. They will not state that they are requiring that you follow 101. They're deferring to OCCP, which is interesting. OCCP's regs defer to VETS, and VETS is now saying, well, we're going to follow what OCCP says is the definition. So I have to be careful here because VETS has not answered the questions specifically. So I'm going to call it sketchy, a new technical legal term. VETS is incomplete statement, and I've asked them squarely to address these questions. You'll know how to proceed. I also know whether they require the definition or which one that you could elect in your discretion. They have not answered that. Here's what I think the conclusion is. They're going to require that you file your 4212 form using the expanded definition. Is a 4212 correction required? I don't, to now cause you to file and report anybody who served during a period of war as opposed to those who only served during a war, that extra 3 million vets that are not reported? Well, I don't think so for 4 reasons. First of all, and I don't mean to be cynical or critical at all, I'm just going to report to you a given fact. VETS doesn't audit the VETS 4212 reports. They have reported in the last several years that they've begun to run reports to see if they are different year over year. But nobody, I hate to tell you, is looking at these VETS 4212 reports and doing anything meaningful with them. They hope to do something one of these days with them, but they notice that you haven't been filing the expanded definition these many years. It has no mechanism to receive corrected 4212 reports. That would be a huge undertaking. Third, you all would have to go back and survey your workforce just to gather the information to report any veterans who served during a period of war but did not serve during a war and are not covered by some other alternative definition. And finally, it's awkward that they're doing this in this strange fashion. I don't think either VETS or OCCP, for that matter, wants to provoke a further roil with federal contractor community and provoke congressional investigation, because the Congress is very specific who wanted it covered. Now, why is that? Why didn't the Congress say 30 U.S.C. 101, but rather said 42 U.S.C. 4012A3? It's for Veterans Act. was part of a massive wall-to-wall overhaul of everything veterans. Many people at the time in 2002, 2003 called it 100-year overhaul of everything vets. And one small piece was OOCCP and vets' piece. But the paradigm, among several others, that emerged in the veterans world as part of this massive overhaul in the Bush administration in 2003, and it was driven by President Bush. It was a culmination of things that the veterans and DOD have been working on for decades. A central thesis. What we want to protect going forward are not people who served in the military, but people who served in harm's way. So if you look at all four of those definitions, these are various forms of people who served in harm's way. Why did they get rid of Vietnam-era veterans? The statute, for gosh sakes. They got rid of them because I could have served during 1964 to 1975, the definition of the Vietnam era, by being in country in Vietnam. Rather have served my entire period of active duty in Louisiana flipping burgers at the local commissary. I'm away. That's why they changed, by the way, the definition of specially disabled to disabled. Because they said, going forward, if you were in harm's way, if you were in a campaign, if you were in an expedition, if you were in a war, we take care of you 100%, even if you're only 1% disabled, not 30% disabled, not 40% disabled, 1%, and you're covered completely wall to wall. That's why these were different and why they eliminated all these other people who did serve in harm's way. And D, by the way, is the one who gets to decide who's in harm's way by issuing campaign and expedition badges or armed service medals. Okay, slide 30. Is OOCCP now going to bust you because you've underreported? OOCCP should require you, if you believe what they're saying, to sign conciliation agreements because you've underreported. That OOCCP will not bust you. For the fourth reason, this is embarrassing, and if the Congress ever looked into all of this, there would be hell to pay. So they're going to bust you. I'm polling, though, to see how this group proceeds. I'm going to give you 4 poll questions to help you with what you will different, if anything, going forward. So the question is, how does the company currently invite protected veterans to self-identify post-offer? Do you ask them to identify themselves as protected veterans without stating the 4 categories? I had 4 different AAPs like that last week, where they just invite on the self-ID form the applicant and the new hire to report, I'm a protected veteran, but it doesn't give them the 4 categories. The second option is state the 4 categories, but you don't define what they are. And number 3 is you state all 4 categories and publish the definitions of each category. So I'm asking you, which one of these approaches do you take? You pick one, and I'll give you a few moments to complete that poll. It says the poll has ended, so do you have some results being? So
we can't see the percentages.
The percentage
probably 70 something.
So most of you have, looks like about 70% have done number 3, the 4 categories, and you publish the definitions. That's best practice. By the way, I took the occasion when Pat Shue was speaking at the Nellie Affirmative Action Briefing in Chicago to, with her permission, poll the audience on her behalf. There are about 140 people in that audience to ask how many published their definitions. And about 75% said that they did. And I said, well, that's a best practice, not required, but a good thing to do because veterans are often confused as OOCCP is. And was very appreciative of that and congratulated the federal contractors for doing that. Now, it looks like there's probably about 10% of you that just simply ask, number 1, to identify themselves as PVs without giving them the categories. and without giving the definitions. You've got choices here. Any right answers under the regs, you can do any one of these three. But let me tell you this. If you're a Category 1 answer or a number 2 answer, you're not going to do anything different tomorrow than what you're doing today. Why is that? Because categories have not changed. It's only definitions of the during war category that has changed. So if you publish your definitions, like about 75% of you do, then you're going to have to go in and change your definitions. And remember those slides 21 and 22, I think it was, where I gave you the expanded definition from 38 United States Code 101. I'll dig a little deeper. This question asks, and you can launch this, Casey, is, do you invite all veterans to identify regardless of whether they are a protected veteran, regardless whether they're 38 U.S.C. 101, any kind of a veteran? Because I have clients who want to protect all veterans. And you won't want to publish, by the way, to vets under 4212 that definition, because that's too broad. But people do want to know that. That is a separate question beyond the 4 categories question, so that they can address that issue. All right, so Casey's going to rack up the answers to see what those percentages are. But my experience is this is under 20% of you that ask about all protected veterans. It's usually the larger federal contractors, and it's largely the ones that are heavily involved in the defense industry that are a contract, if you will, under their rules of engagement with their employees, their employee handbooks, protecting everybody and giving them special recognition regardless of whether they're a protected veteran or just a veteran. So the answer appears to be that about almost half of you are inquiring about all protected veterans and about half are not. That's up to you to do in your discretion.
All veterans, not all protected veterans.
Not all, discretion to ask whether somebody is a veteran who is not a protected veteran, whether the during a war or during a period of war definition. I don't want to report the non-protected veterans to your 4212 form. You will not want to report them for your effectiveness of outreach for OCCP outreach purposes. You won't want to include them in your hiring metrics, your 44K data metrics, as we'll talk about in a moment. So let's do number 3, poll question 3 that Casey's launching. Did you report on your VETS 100A? And I'm consciously saying 100A. You have to think 2 years back now. Veterans who served during a period of war, yes or no, or maybe you did ask your new hires, so you don't know what they reported. Said, if you're thing number 3 did not ask our hires or C, maybe you don't know because you didn't give them a definition. So I want to see if there's indeed underreporting here, or whether you have been reporting during a period of war. Experience is that knew what this definition was until OCCP put it up on the infographic, so they have not been reporting it. But that's the real question as we wait for the poll to assemble the answers here now. Well, next question, by the way, is for you to get ready for is, well, what's happening currently? I'm going to ask you about the VETS 4212 form, so you can compare if maybe over time you're starting to become more sensitive. The being is that not a little bit more than a third of you have been asking your new hires about it's during a period of war or during a war, so you don't know what you've got, I would suggest to you. Very few of you have been asking about whether they served during a period of war. It looks like 12%. So 8% of you have not been asking the definition of during a period of war, which is about what I thought. About 9% of you have not. So let me ask the final poll question that Casey will launch. Did you report on your Vets 2212 form vets who have served during a period of war? I'm trying to get more current information than the Vets 100A. Let's see if there's change over time. I doubt much change will be reflected here, though, because most of you weren't even aware of this during a period of war definition until the graphic hit, and everybody said, what the heck? What's going on there? Another couple of seconds to record that answer, and then Casey will close the poll, and it takes 20 seconds for the computer to assemble all of your answers. So if you've underreported, as I say, I'm going to give you some solace on that. That I don't think is going to cost anybody for that. And of course, you have no obligation to even be providing these definitions to your new hires. And we get out the same answers. A few more of you answered physically, but we still get actually a smaller percentage than we did before on the Vets 4212 form. We get less than 10% of you have been reading on the 4212 form during a period of war. Rather, you've been reporting the war or you don't know. Okay, well, let's thank you with that help, Casey. Let's look at the last piece of this substantively and then get to the practical stuff. OSP, also, you have to worry about the Secretary of Labor because he's a different institution than either VETS or OFCCP. He has authority under 4212B, in the verbatim language, to receive a complaint if anybody feels like they are having a contractor who is violating VEVRA. Now, I say that for my very big federal contractor clients that would just die 1,000 deaths if their CEO were to read in the paper that somebody had filed a complaint that the company violated VEVRA because they're so federal contractor heavy and so concerned about their treatment of veterans. The Secretary of Labor, I suspect, knows, will deny these complaints if you are following OFCCP's rules, because it would be very incongruous for him to say that OFCCP and VETS just undertook an illegal act. But absent the Secretary's exercise of discretion to tell us affirmatively that they're not going to countenance complaints filed by the vets covered only during a period of war, you do not have total solace. You don't have a total conclusion and safety that the Secretary won't disagree with VETS and OSCCP. I'd like to see a statement out of the Secretary's office that they will not grant because you violated the rules but followed OSCCP's FAQs. That's a thing to convince lawyers to get comfort with, that we're going to follow an FAQ and not a regulation or statute. Let me go through quickly why we know that OSCCP and VETS are in error, so you can make the argument convincingly to OSCCP if you do get a complaint either to the Secretary's office or to CCP nomination, perhaps. OSCCP historically gets 200 or 300 of these a year of the country. Here is your punch list. The Veterans Act eliminated Vietnam-era veterans from the definition of protected veterans, so you can't be adding them back in now. Number two, the CCP's preamble is clear that they were not covering Desert Storm veterans just because they were a veteran storm veteran. They didn't reach that issue and suggest alternatives and speculate about possible coverage under alternative theories as a recently separated or as a campaign badge holder. They could have just said, well, Desert Storm is covered because it's the Persian Gulf War and 38 United States Code 101 covers it. They didn't say that. Rather, they struggled hard to say it's not, but be covered under one of the alternative definitions. Number three, and the hip aid. None of the statutes, none of the regs refer to during a period of war. They only refer to during a war. And fourth, yes, contractors make mistakes, lawyers make mistakes, HR consulting companies make mistakes, but can you reasonably believe that tens of thousands of contractors and thousands of HR consulting firms and law firms were wrong when they advised their clients to follow the during a war definition and not the period of war? Now, I don't think there is a problem here with malpractice for either the lawyers or for the HR consulting companies, many of whom are covered under one of the 30 state laws that outlaw and make actionable professional negligence, like malpractice lawyers. I'll come in a moment. But what to do? I wouldn't do anything different if you were one of those who did not publish the categories. I wouldn't do anything different tomorrow. You don't have to do anything different if you don't wish to. Said, you are one of those who answered number 2, that you published the categories but not the definitions. The categories have not changed. It's only the definition that has changed. But if you are one of those of approximately 70–75% of you on this call, which is consistent with my polling of the Nelly Affirmation Briefing audience, if you're those that publishes the categories and the definitions, then you're stuck with a choice. You're going to follow OSCCP's new guidance and push the during a period of war definitions that includes all things on slides 21 and 22, the Korean War vets, the Vietnam era vets, the Persian War vets, etc. We're going to violate OSCCP's current interpretation and stay with what you've got currently. An alternative to that is to not publish your definitions. And then you won't risk that you're violating OSCCP's rules by not publishing the during a period of war definition. But best practice is for you to publish definitions. The lawyer to make a decision about, though. You guys need to decide for yourself whether you want to publish the categories, and if so, whether you're going to publish the definitions. I think the best practice to publish the definitions, because most of these people are kind of lost in the welter, as you see vets and OSCCP are. I'm going to apply your expanded definition. Here's what you need to do. I'm going to give a punch list now. Broaden your reporting on your effectiveness review on the OSCCP side of the house, because your 44K data metrics ask you to report the veterans. And we know who those protectors are, and you're going to use this broader definition. Tell me about that. You would convert your self-ID definitions, if you're going to do that now, January maybe. You have to advise OSCCP? No. If you have to be very transparent, you might publish a footnote definition that as of January 1st, January 15th, March 1st, whatever it is, that changed your definition for purpose of the 44K data metrics to capture the broadened definition, but you don't have to do that, and I suspect most of you will not. Fourth, you could do a survey of your incumbent employees for purpose of the Vets 4212 reporting next year to see if you pick up any veterans who are veterans of a period of war, even though they're not a veteran of a war. But you do have to resurvey, and I've given you the 3 reasons why that's historically true. The VETS change is an error and it's illegal. See my section 6 above, that's why I went through that for you. Number 2, OMB is loath to approve or require surveys. They know that's time-consuming and burdensome. I have clients who don't think anything of surveys. I have other clients who say, over my dead body, will we ever survey all of our employees about anything? We hate that. And number 3, this doesn't currently require resurveying, for example, recently separated veterans who are constantly, every day, dropping out of the definition of protected veteran because they're more than 3 years out of active duty. Does it really matter? Let me end with some happy news. At the end of the day, really matter, and none of this is going to affect the quality of your compliance I submit as to OSCCP's protected veterans. And that's because even if you exceed the 7% benchmark for hiring, even if you don't achieve it, you're going to have to do outreach and recruitment pursuant to your new effectiveness requirements that are in the March 2014 regs. So even if you're in nirvana, you're 100% veterans. You still have to do that effectiveness review and still keep outreach and recruitment going to protected veterans. So there's no difference in what's going to happen to you at the end of the day. If I should take a really good bow right now, all of you in this audience, because the Bureau of Statistics reported in November that veteran unemployment is now 3.6%. Congratulations. I've given you a citation to the Military Times report of this. That's the lowest veterans unemployment rate since 2007, in the last 2 years of the Bush administration before the 2008 blowout and recession. A 7-year low. Note, there are more jobs available than there are veterans now to fill them. There are probably a few thousand here or there veterans not employed, but in America, 4% unemployment is considered full employment because Monday morning when the BLS shoots the unemployment photo, 4% of us are typically changing jobs, moving from job A to job B, what the economists call structural unemployment. So somebody's got a state or a county has 3% unemployment. That tells me they have more jobs than they have people available to fill them. That story with vets. Here's bad news with vets. After this happy news, you're not getting vets on employment rolls from the immigrant rolls. You're getting vets from your neighbors who have already employed them. But that's a very good story for contractors, and that's a very good story for veterans.
Thanks, John, for all that information. We've actually gotten a lot of questions. I think the questions we had earlier, one was, can we ask former military and veterans, but not protected veterans in your self-ID forms? And I think I answered that question.
I would ask that as a separate question, though, because you're not going to report them for 4212 purposes. You're not going to put them into your 44K data tricks for your effectiveness review.
Okay, I guess Keith, 21. Somebody wanted us to go back. There we go. Somebody wanted to go to slide 21 and 22. I think you were looking for the definite, and you will be receiving these slides within the week. So hopefully somebody had asked to go back to those slides. But will the OSCCP, this is interesting.
Could I just piggyback there?
Sure.
Where do you get all these definitions? In 38 USC 101, but also
you can Google that.
And also have Candy publish for you a wonderful February 2015 Congressional Research Service report on periods of war. And it gives elaborate definitions, paragraph each, on each of these things I have listed on pages 21 and 22. If you want to know more about what the conflict in Grenada was, for example. The Congressional researcher has cataloged all of this very carefully. If you don't have that, you don't really have the master list of all these periods of war.
I will make sure that we get that published this week. So one question, let's see. Oh, and one commenter had concerned that they served but did not serve in an area where a campaign badge was authorized. For instance, a medical doctor for 22 years but was not in the combat zone. Why are they not classified as protected veteran? I think we covered that because they weren't in harm's way. So that I think is covered. And that's, you don't have to like that. That's just what they came up with.
Hey, the Congress's definition.
Yeah, so talk to your congressperson. Okay, this question, because I feel from when I was a federal contractor myself, will the OFCCP be changing the definitions as stated in the VEVA regulations? And we copied the definitions to create the forms. Although it sounds like it will be easy to change, it is such a pain, capitalized, to change these forms in electronic systems. And that is exactly correct.
Yeah, changing the categories, though. The 4 categories of definition that come from VEVRA and from the rules have stayed the same, I showed you in the FAQ, they say they're changing just the definition of during a war veteran to mean during a period of war.
My suggestion, as a person who is in charge of getting this accomplished as a federal contractor myself, I would honestly have an extra piece of paper or extra electronic page when you have your self-identification and just have these definitions on one page. Like we used to have to do when we did the self-identification anyway. You had the entire page of definitions and the campaigns associated with it. Would you agree? Okay.
I think it's the best practice.
And I think this is
not required, but a best practice.
And I think this is a record for a John Fox webinar. It is 4 o'clock, and we're done. We have answered every question that we have received, and I hope you found this of value, and I hope this doesn't scare you, because I think, as John said, it doesn't really matter that much, except for giving credit to all of the veterans in the workplace. So with that, thank you very much for participating today. We will send out the slides and a link to the recording, and I look forward to inviting you back to our webinars next year. And in the meantime, have a wonderful holiday and a safe and happy New Year. Thank you.